5 seconds. Start. Now, sir, it is said sometimes that young people do not have much experience. I can understand that. If we judge it merely from the point of view of time one has served on the bench, to some extent that experience would be lacking in the case of a young person immediately recruit from the bar. But then he will bring in other things which may be lacking in the older man. The whole thing should be so developed that it becomes mutually complementary. A young person will have more courage and he will have more initiative in the matter, because a judge of that kind would like to excel not through age, nor by putting in a greater period of service, but by making certain positive, creative contributions to the development of the entire system of law. Therefore, it is very essential that young people are recruited, and I think almost in every high court bar we can get some young people who can discharge the responsibilities and who can be safely entrusted with the discharge of this responsibility. The government should seriously consider as to why we should keep stuck up to the old system or arrangement in this matter when we can try it. I do not think it is a risk. If there is a risk, I would suggest that this risk be taken, if only by way of an experiment to see how things work. We can give up this kind of approach if it is found unsatisfactory. Then, sir, many things have been said about the cases in arrears and so on. Cases will accumulate before the Supreme Court. Why? Because growingly there will be conflict between the propertied class and those classes which do not have property or have very little property. The vested interests are bound to come up against resistance and opposition on the part of the have-nots and the underdog in society. If we at all mean to advance in our national remaking, then this will, under the present system of law, give rise to a whole number of litigations. And I am not surprised that the litigation is increasing, having seen how whenever a thing goes against the employer in an industrial dispute or a tribunal, the boss class rushes to the Supreme Court and appoints important lawyers. Some of them are now, of course, in political parties. So, I can tell you that the number of cases is 2500 or so. I do not see any possibility of this number decreasing for two reasons. The vested interest will more and more come to the Supreme Court under Article 136 and sometimes by invoking the fundamental rights to the challenge even the progressive legislations of the government and the progressive decisions of the tribunals. Did we not see how, when certain laws were passed, they went to the Supreme Court to challenge the actions of the government because, to some extent, they affected the interest of upper classes?